We are back for the Donna Adelson pretrial hearing. And I'm very interested in seeing what they came back for to talk about, because she had her next hearing for May, I think it was May 12th, and yet here she is. And she didn't even do a Zoom this time. She actually went to the court. Let me go ahead and get it playing. I need to remind myself, I keep wanting to try to find, why does Donna do Zoom calls instead of going? And then some days she goes and then only Zoom. Almost done. There it is.
This afternoon in State versus Adelson, 2023 CF 3226. This is the defense's renewed motion in limine, I believe, concerning impeachment of witness Wendy Adelson.
Woo.
This afternoon in State versus Adelson, 2023 CF 3226. This is the defense's renewed motion in limine, I believe, concerning impeachment of witness Wendy Adelson. Mr. Zellman, you may argue when you're ready.
Thank you, Your Honor. And Your Honor, the only piece of evidence that we're going to be offering prior to making an argument is Ms. Wendy Adelson's CV from December of 2012. It's marked as Defense 1. I don't believe that there's an objection.
No objection.
And it indicates on the second page, Your Honor, that the book issue was originally published September 15th of 2011. With that, Your Honor, the significance of that date is obviously it was prior to when Ms. Adelson filed for divorce in 2012, certainly about 2 years prior to the hearing where her petition for relocation was denied. The reason why those the state's position was that the storyline of Ms. Adelson's book was relevant for impeachment purposes because the defense's cross-examination opened the door. And I quoted the argument that was made on August 30th of 2024 by Ms. Kaplan concerning why she believed the door was open. Well, I first want to submit, Your Honor, that the concept of opening the door is triggered when one party's evidence presents an incomplete picture, and fairness demands the opposing party be allowed to follow up to clarify and make it complete. That's from Brunson v. State, 31 Southern 3rd, 926, a Florida first DCA case from 2010. Now, the underlying...
Before you go on with that, and that case does bring up a good concept, but isn't this largely dependent on what Ms. Adelson is going to testify to on the stand?
Yes, but in order for it to be proper impeachment, the underlying requirement, I think that's inherent in the rules of evidence, is that the fact that the opposing party wants to clear up is actually true. And so the state has to take the position that this is our story, written by Ms. Adelson, is autobiographical. And because it's autobiographical, how the main character feels about the city in which she lives with her husband, who's a professor, is relevant almost 2 years after the fact to how Ms. Adelson felt about having to remain in Tallahassee after the petition for relocation was denied. Now, the main fallacy of the argument, however, is that first and foremost, the book is not autobiographical. And I've read the book. I have the manuscript that was originally submitted to the publisher. The main character had a miscarriage, leaving her unable to have children, and she ultimately adopted a former client's abandoned child. There's no evidence that Wendy Adelson did those things. And that's just one glaring example of how the book is not autobiographical. Now, even if it is autobiographical, the state's position is factually inaccurate. The state's position, both in the hearing and prior trial, was that the main character of this book, Lily Walker Stone, was utterly miserable and stuck in the place she was living. Now, that position would have been accurate if you stopped reading halfway through the book. On page 233 of the book, there's a passage I'd like to read for the court that highlights the fallacy of the state's position.
Go ahead.
I'm so sorry, Josh, for everything, and I'm grateful to you, for bringing me to this place, for giving me wings to try something new, and for all the unpredictable experiences that have followed. She's thanking her husband for bringing her to the fictional city in which they live, the fictional city in which he teaches, the fictional city in which she practices law. So, contrary to the state's position, she ultimately is happy where she's living. She's thanking her husband for bringing her to the city, not the opposite, which is what Ms. Kappelman and the state in the prior trial and at the hearing in August were representing. And since the factual basis for the state's questioning is patently inaccurate, it's our position that it would be improper to use that for impeachment. The other issue that you have is what I mentioned previously. Originally published September of 2011, the petition for relocation is denied in June of 2013, almost 2 years. And so the best example I can give, or comparison that I can give to the court, is people fall madly in love, get married, and then they think they're going to live happily ever after. But after a time, they realize they were wrong and get a divorce. As a judge, certainly I've seen it with family law. People get married and divorced, sometimes in a very short period of time. Mm-hmm. So how they felt on the day of their wedding is going to be very different from how they feel when they file for divorce or when their divorce is final. So I think that the timeline, even if this were factually accurate and it were autobiographical, the timeline itself leads to an issue with 403. The probative values being substantially outweighed by the danger of confusion of issues and misleading the jury. It's also needless presentation of cumulative evidence, Your Honor. There's other evidence that the state...
Was the book entered into evidence? I don't believe it was.
No, it was not.
Strictly impeachment.
Yes.
Go ahead.
But you're confusing the jury with the book as evidence that Ms. Adelson was not happy after her petition was denied. When the book doesn't say that, the book actually reflects the opposite. And now, if that is allowed, we're going to have to then clear that up for the jury because that's not what the book says. And at that point, we might have to introduce the book into evidence. That's a waste of the jury's time. The issue is...
Turn the trial into a book club.
It's not an easy read, I'll tell you that. But, Your Honor, it's our position that both from a factual standpoint and a legal standpoint, that the state's use of this book, even for impeachment purposes, is inappropriate.
All right. One final question, and I'll allow Mr. Evans to argue from there. As to any bias or motive that could be argued, do you have an argument concerning that?
No, Your Honor. I certainly understand why the state believes that it goes to bias or motive. That's not what I'm addressing here. I'm addressing the underlying factual inaccuracies in the state's argument.
Mr. Evans, you may respond.
Your Honor, I believe that would go to weight, not to admissibility. The fact is that this isn't an isolated statement. I think it shows a continuation. I think there is indications that there were some parts about the book that she included, comparable things. But again, that doesn't mean that the book has to be totally autobiographical in order to have parts of it missing. We have situations here where White also, not only did she write a book which covered that area, she has also emailed friends, and throughout the time there was that the relocation was important to her. That, matter of fact, they filed a motion to do it, and that she had emailed a friend in December of 2000, actually like Christmas Day, that she felt like she was stuck in Tallahassee. She did something similar in February of 2013, and that life in Tallahassee, and in just May of 2013, that life in Tallahassee couldn't compare to life in South Florida. That they were in the motion for relocation indicated that that she was stuck in Tallahassee, and that she wanted to get out of this tiny town, and the book, she related how miserable it would be to be stuck in Tallahassee. So I think it is relevant. I think it is admissible. It's not an isolated statement. And when you take everything in context, I think it is admissible that she felt so strongly about this. She had written before. And like anything else, if we bring up the divorce scenario that people talk about, well, if this was a festering issue, which it sounded like it was, according to the pleadings and stuff that was put in, and statements, other statements made, that in the book it may come out as a happy ending. On the other hand, in real life, it certainly did not. And I think that is relevant for the state to be able to probe, to ask. I don't think it's a remote statement that,
Well, let me clarify, I guess, what you're trying to argue, Mr. Evans. Are you arguing this is substantive evidence that you will admit, or just impeachment of Wendy Adelson?
I think it could be both. At the times it has been being used as impeachment evidence. I don't know that it has been introduced as being substantive during the trials before. But there's been a number of them, and so I don't recall that. Your Honor may recall it better, but I don't at the moment. But it would certainly be right for impeachment. If she gets up on the stand, I think she has somewhat consistently indicated, oh no, she was perfectly happy in Tallahassee. And there's evidence to suggest that isn't a correct statement, that isn't a true statement. And it was one of the reasons that, in fact, the defendant had related, I think there seemed to be some indications from what, and I'm looking at some of Ms. Kaplan's notes, that she was called a hostage or a prisoner in Tallahassee in an October 2012 email. That then the defendant also expressed concerns that as a Tallahassee native, the judge provided a relocation motion, would see nothing wrong with living in Tallahassee, but as a native of South Florida, that she would know better, and that she believed that getting stuck in Tallahassee would ruin her life. This was the defendant relating, I believe, back to her daughter about her situation. So I think it's a situation where it could both be substantive in one sense, but it certainly is ripe for impeachment if she gets on the stand and denies that she was unhappy in Tallahassee, at least at some points unhappy in Tallahassee, which I think she has consistently done over the trials, and that was the reason the stuff has become impeachment.
In response, Mr. Zillman.
Briefly, Your Honor. We're talking about Donna Adelson, not Wendy Adelson. Donna Adelson is the one on trial, not Wendy Adelson. And if the state has emails from Wendy Adelson in which she is expressing a dislike or being stuck in Tallahassee, they're certainly able to use those emails for purposes of impeachment. It has nothing to do with the book. And Your Honor, it's our position that even if it meets a relevancy threshold, the book, it still would be needlessly cumulative, and it would lead to confusion of the jury, because again, as I said, and I read the passage from the book, the main character did not feel stuck in Tallahassee and thanked her husband for bringing her here.
Right. As it concerns the use of impeachment against any witness, as a general matter, impeachment is available to show whether the witness is being inconsistent with other prior statements, untruthful, has bias, or has motive. I will give additional consideration to the request that's been made by the defense, but as to the general proposition of law, I believe we're back to what the first question was to the defense when we had the hearing. This is largely going to depend on what Wendy Adelson actually testifies to. If she testifies in a manner that is inconsistent with prior trial testimony, or otherwise could demonstrate bias or motive that can be attributed to the defendant in some way, she can be impeached on those topics, whether they be the book or any other matter. I will give additional consideration to this. A written ruling will be issued. We are in recess.
Thank you, Your Honor.
I had to bite my tongue during that when the defense attorney said, "This isn't Wendy's trial, it's Donna's." Wendy should be having trial too. She should be arrested. She had to know or been involved or something. I really don't believe that she doesn't know anything. So frustrating. I believe this is still, the start date is still like 3 weeks away, right around there. We're getting close. Wendy, it sounds like Wendy's going to come and testify, which will be interesting. She's living in South Texas, near the border. I wonder why. So it'll be interesting her going back there and probably trying to help her mom and support her mom. But I hope that something happens and it is out there that Wendy knew or helped. I really think she did. So I will stay watching that. Anyway, I have one more video that I'll be doing, playing catch up a little bit. I'll probably try to do it right now, if not right when I get back with the girls from school. But either way, I will catch you later.